the safety of people, that they are not going to be kidnapped or threatened, their lives threatened.
Jesus. Sorry, hold on. Somebody said, wasn't Destiny against removing it from the start? Okay, hold on. Please listen. I don't remember what my opinion is at the start. I don't know what I said at the start. And by the start, I mean like months ago. Okay? When somebody asks a question of like, are you for or against getting rid of a particular thing, you know, in the United States, if you're going to ask a legal question, then that demands a legal analysis. So that's why before going to the oral arguments, I wanted to read at the very least the request for the writ of certiorari or whatever, and then just have some understanding of what the case is about. Because like I might say something like, somebody might say, oh, they wanted to ban TikTok for national security interests with the president. And that might sound like a legal argument. Oh, okay, national security, sure. And I say, yeah, I guess that's probably okay. But let's say that the law they passed to do it was, the law says the president at any point in time can dictate any country as an enemy to the US. And if any platform says anything good about that country, then that's a compelling national security interest to ban that, boom. In that case, even if I'm for banning something for national security interest, the legal analysis would be like, no, what the fuck? The president can't just declare anybody an enemy and ban the thing. Legal analysis is important for legal things. And it's different than just an opinion. Now, I know that like everybody wants to have an opinion about everything, especially fucking political commentators, okay? But to have an opinion about a legal case, it should be done through the lens of a legal analysis, okay? To be clear, I don't have a formal legal background, and I haven't read the defendant's side of this, so I don't know what Garland or the DOJ or anybody on his behalf filed on their side, so I haven't even seen their arguments. So it could be really compelling arguments on their side. But just on its face, the idea that Congress could pass a law that allows the president to ban any social media company as long as there's a 20% equity holding from a foreign adversary, I don't know how I feel about that. I don't know if that feels to me like something that should survive First Amendment protections. I'm not convinced of that, but maybe I will be by the end of this. We'll see.
To be kidnapped or threatened, their lives threatened. You don't think that the government has a compelling state interest in saying, if there is a threat, a physical criminal threat against someone to do some activity, that the government couldn't say, I'm not questioning whatever the content is of that activity. I'm simply saying we, in our governmental powers, have a right to say, you can't do that.
No. Well, it has to be specific, right? So like looking at, say, one thing that I brought up with Pisco is like the Brandenburg test. Just because something might lead to something bad doesn't mean, even if it might lead to like harm or people dying, that's not enough to go against somebody's like right to free speech, right? So like when it comes to inciting like a riot, right, for Brandenburg test, in order to criminally charge somebody for incitement, the Pisco said there were 4 elements. I thought there were 2. This says 2. Maybe there were 4 in some other place, right? So in order for this, the speech is directed to inciting or producing imminent lawless action, and the speech is likely to incite or produce such action. I think broad threats or broad claims about Jews or national security or whatever, I don't think they would ever survive, at least for the crime of advocating legal action. So I think it has to be more narrowly tailored, whatever law you're making, to make some kind of speech illegal. It needs to be more narrowly tailored than to just say there's some national interest. However, again, remember, because I don't have a legal background professionally or academically or whatever, there could be that the state or the president might have additional ability to say that I can criminalize something. Like maybe there are some things here that aren't like on an individual level or something that I just don't know about, but we'll hear about it. Okay.
So powers have a right to say, you can't do that. You can't speak.
Sure, Your Honor. So to take your question in pieces, I do think that they would have a compelling interest in that scenario to do something. But what I don't think is that they could simply target speakers in speech. Take, for example, generally applicable laws like the trading. So
you think in that situation that the only thing the government could do is tell the Washington Post, disclose to the public that you are saying this because you are being forced to.
Yes.
So, sure.
That's the only remedy the government could undertake?
No, Your Honor, but I want to make sure
well, what else could they do? I mean, if we're saying like threaten them, like by extortion or blackmail, then that would be bad. But those are separate crimes, right? Those are all crimes already.
understand the hypothetical. The compelling interest is in preventing this kind of compulsion, coercion, and ultimately harm to children. And I think that the government has a lot of different ways they can address that through speech-neutral laws. And I was going to point to things like the Trading with the Enemy Act or Russia sanctions. You can broadly say and attack problems.
They haven't been very effective.
Well, be that as
we're still having people kidnapped. We're still having coercion.
And be that as it may, you can say to Americans, you cannot collaborate with our enemies at all. And if you do that, you're going to be severely punished for doing that.
All right, we can go on to the effectiveness of the remedy. But the point is, I believe, that even if your First Amendment rights are impinged and there is some protection, the question is at what level of scrutiny?
Yes, Your Honor.
And whether that the action is content neutral or not.
I agree that that is the way that the analysis proceeds. Here, we believe that the level of scrutiny should be strict scrutiny.
What is the relevance?
Why are the judges allowed to just interrupt them? That's mean, okay? They should have to say, excuse me.
That the level of scrutiny should be strict scrutiny.
What is the relevance of the history? Chief Judge Srinivasan, in his opinion, in the D.C. Circuit, emphasized that there is a long tradition of preventing foreign ownership or control of media in the United States, going back radio, television, and what have you. I would think no matter the level of scrutiny, that history has to be important, and I want to get your response to it.
I don't actually think it's important in this context because that history all arises
and what have you. Media in the United States going back there's a Srinivasan. What is the relevance of the history? Chief Judge Srinivasan, in his opinion, in the D.C. Circuit, emphasized that there is a long tradition of preventing foreign ownership or control of media in the United States, going back radio, television, and what have you. I would think no matter the level of scrutiny, that history has to be important, and I want to get your response to it.
I don't actually think it's important in this context because that history all arises in the context of bandwidth scarcity. And in that context, you have the government that's in the position of doling out a limited number of licenses. And when you have to dole out a limited number of licenses, you by definition have to pick winners and losers. And when you have to do that, you get a certain amount of discretion. I think that's the whole basis of those cases. You can't really take those cases
keep going.
You can't really take those cases and extend them to an area where there is no scarcity, like the World Wide Web, because once you do that, there's really no limiting principle. There's no reason why it wouldn't also apply to really popular books or magazines or newspapers or chains of newspapers. The bandwidth scarcity, I think, is really what justifies the greater discretion that the government gets in that area.
Mr. Francisco, let me see if I can break this.
So that was interesting. So was that Gorsuch? Fuck.
You can't really lose the rises in the condition of doling out a
Oh, that was Kavanaugh. Okay, that was Kavanaugh. So Kavanaugh brought up, I don't know what this case is exactly, but Kavanaugh brought up the idea that there's a history of media not being owned by foreign companies, and this court case that's brought up. And Francisco I imagine they either just have a huge library of knowledge or they know which cases are going to be brought up. Well, it sounds like this one was specifically referenced by the lower court. And the argument as well, it seems like in the past we've doled out licenses are not based on, who the owners are or national security interests or whatever, maybe something like that. And Francisco's argument is, well, hold on, these are licenses for, there's a limited number of these. This is way different than trying to ban a social media company. It's not like there's a limited amount of space on the internet or there's a limited amount of bandwidth or something and we have to choose winners and losers. This is a speech law that's being made that abridges or obstructs my First Amendment right for no compelling reason. There's not a limitation here that would apply like it would in that other case.
By the People's Republic of China. That
Scarcity, I think, is really what justifies the greater discretion that the government gets in that area.
Mr. Francisco, let me see if I can break this down. Suppose that TikTok were outright owned by the People's Republic of China. Would you make the same argument?
I wouldn't be making the same argument, Your Honor.
Why not China? That TikTok were outright owned by the People's Republic of China. Would you make the same argument?
I wouldn't be making the same argument, Your Honor.
Why not?
So he's saying, what if TikTok was just owned by the People's Republic of China? Would you make the same argument? And he's saying he wouldn't make the same argument. My guess is a lot of this strict scrutiny, the argument for the strict scrutiny review is going to be that TikTok is a U.S. company. So all of the First Amendment rights apply. If this was wholly owned by a foreign entity, I don't know if they would enjoy the same constitutional protections.
Because there you would have to confront a very different question, whether a foreign government that was speaking in the United States has First Amendment rights, and I don't know that the court has ever addressed that. But here we've got a U.S.
No, I understand that. I just want to see where you draw the line. So it's true, the court has never held that a foreign government has free speech rights. And if we were to hold that, I would think it would be because speech by a foreign government, particularly one with enormous resources, is not protected. Allowing that does not serve the underlying interests of the First Amendment, which are, among other things, fostering democratic self-government and furthering the search for truth. So let's assume that we start with that, all right? What if TikTok were then not owned by the foreign government, but it was undisputed that TikTok was totally controlled by the foreign government, could not do one thing without the approval of the foreign government?
So somebody in chat asked, what's the difference if they own them or not de jure, but they de facto control it? So de facto means that not by law, but basically like it is the case. And de jure means like it's not delivery, it's DiGiorno. I need clappers for that. I'm sorry. De jure means it's written in law that they do control it. So now Alito is asking this question. Fuck you guys.
By the foreign government, could not do one thing without the approval of the foreign government. That's different?
I do think that it is different, Your Honor. For example, I've given the hypothetical that I've given, but there are a lot of companies in this country that have foreign owners, not just companies like Politico, which is German-owned, or Al Jazeera, which is partly owned by the government.
Well, I understand that, but what would be the reason for drawing that line?
Sure,
if there's a good reason for saying that a foreign government, particularly an adversary, does not have free speech rights in the United States, why would it all change if it was simply hidden under some kind of contrived corporate structure?
Because
I feel like the strongest argument in favor of the TikTok side here is because if you were to say, let's say that you are basically controlled by a foreign government, well, we wouldn't want to give that company freedom of speech. Sure. What about an individual then? What if it comes out that, or what if I even freely say, China's just like telling me like, hey guys, we're going over Chinese talking points today. This is where they email me, let's go. Could the government come after me and shut my speech down because I'm getting direct, even if I was and I admit fully, like 100%, like China tells me everything to say, would I be implicated there? I feel like, I don't think, as long as I'm making my responsible disclosures or whatever, I'm not receiving money and not disclosing or something, I don't think the government could come after me for that. Should they be able to? I don't think so. But
if it was simply hidden under some kind of contrived corporate structure.
Because it is a U.S. speaker.
Yes.
I'll give you another example. AMC movie theaters used to be owned by a Chinese company. Under this theory, Congress could order AMC movie theaters to censor any movies that Congress doesn't like or promote any movies that Congress wanted. And I think the reason is that here, where it's conceded, you actually have a bona fide U.S. company. It is not simply a Chinese cutout that is the Chinese government speaking itself.
That's true too. The facts, that's not something that's being alleged here even, is that TikTok is a 100% foreign directed company. So it's not really fair for that consideration to be made because it sounds like the DOJ didn't even make that contention. They already conceded, yeah, TikTok is a U.S. entity, sure. We agree with that, yeah. And then they're moving from there, right?
Not simply a Chinese cutout that is the Chinese government speaking itself,
all right,
but
let's
an
say that's
independent
not a
United States company.
Let's say this is not a complete answer to your First Amendment argument, but would you be willing to concede that this is a very important factor that should be taken into account in deciding whether there's a First Amendment violation.
Would this be an important factor? Whether there's a violation, is it whether there's a violation or whether or not the government can make the law against it? It would be an important factor, right? Because it's one of your two prongs, like the compelling state interest, but you have to satisfy the second one, which is showing you're making a narrowly tailored, like a speech-neutral law, I guess.
Well, Your Honor, I think that it does help supply a compelling governmental interest, but I still think you have to march through the strict scrutiny analysis and analyze
and have the
their
narrowly
interests.
Tailored, yes,
I do not think that they have a compelling governmental interest in the manipulation of content. I think that is in the teeth of the First Amendment, and if you look at the government's brief and the rest of the record in this case, that's really what it's focused on. Their complaint is the fear that the content could be critical of the United States government or could undermine our democracy. Yes, Your Honor.
Mr. Francisco, I just wanted to follow up on that line of questioning with just some fact questions, because it seems to me there are a couple of things that the parties still dispute about facts in this court, which is a little unusual. The government says that TikTok, U.S., has no authority or ability to alter the algorithm or recommendation engine, but must simply follow ByteDance's directives. You disagree with that in your reply brief.
Yes,
somebody has to be right and somebody has to be wrong about that. What's the fact? What does the record show on
Well, Your Honor, we are.
So I believe, I think legally there's something called a court of first review. I think is what I don't need to guess any of this. We can just Google this. But when a Supreme Court is deciding something, unless it's a case they have original jurisdiction over, that they're the first people to hear it, the Supreme Court, I don't think, typically considers questions of fact. It is not considering what the facts of the case are in terms of what's right or wrong. They're just considering the legal question about it. So, like, if something gets to the Supreme Court and it has to do with anything, with whether Trump gets like the Trump immunity case is a good example. The Supreme Court is not there to decide, okay, well, do we think that he did this thing or did he not do this thing? I think the Supreme Court just accepts the facts as presented to it from the appeal of the lower courts, and then it's only engaged in matters of legal review, not a factual review, I believe. Except maybe when they have original jurisdiction. So if they're the first court to hear a case, like if a state brings a case to it, but I don't even know in that case if they ever do a fact review. I'm not actually sure, but yeah, okay.
We are here on a record, and there is nothing in the record that says that TikTok, like any other subsidiary, doesn't have its own independent making authority. If you look at their record sites, what they point to is the ordinary types of control that a parent company has over a subsidiary company, but it doesn't change the fact.
All right, what is the fact? Are you prepared to make a representation?
Yes, Your Honor. The fact is that.
I wonder why. Should you even have to answer this? If the other side's not contesting these facts, then why even bring it up? Yeah, go, fuck, they didn't even fucking bring this shit up. We don't have to talk about the facts here. They're not relevant. Isn't the argument that TikTok does have freedom of speech, but because ByteDance is directing its speech and China does not have free speech in the U.S., Congress can regulate its speech? I don't believe that's the argument that the Department of Justice is making here. So I don't think that should be an argument that's up for consideration for the Supreme Court, right?
TikTok Incorporated as a U.S. company does have a choice over the algorithm. Now, it would be an incredibly bad business decision for them to abandon this algorithm, and they very doubtful would ever do it, but they have that authority. What they clearly have the authority to do is shut down the platform in the face of Chinese pressure. That's actually what they agreed to do in the National Security Agreement. I think that underscores why TikTok Incorporated as a U.S. company does have its own set of First Amendment rights.
Okay. And then
somebody said Supreme Court doesn't do first review. The Supreme Court, I believe, does have original jurisdiction in certain cases. One of those would be, I think, when states sue other states. I believe that the Supreme Court has its original jurisdiction is what I'm saying, right? They're the ones who have the first look. But I don't know if they then do factual consideration there. Original jurisdiction refers to a court's authority to hear and decide a case for the first time before any appellate review occurs, yeah. But I don't know if they do fact-finding there or how that works. I'm not sure. But
scores why TikTok they agreed to do in the National Security Agreement. I think that underscores why TikTok Incorporated as a U.S. company does have its own set of First Amendment rights.
Okay. And then another fact question. Before the D.C. Circuit, you argued that the Chinese government has made clear in public statements that it would not permit a forced divestment of the recommendation engine. Does that mean that some key component of the recommendation engine is under Chinese control?
No, Your Honor. What it means, and this might warrant a little more explanation, what it means is that there are lots of parts of the source code that are embodied in intellectual property that are owned by the Chinese government, and they would restrict, like the United States restricts the sale of those types of things to foreign governments. It doesn't alter the fact that this is being operated in the United States by TikTok Incorporated.
Okay.
So
I got it.
Okay.
I got it. And then you represent that the divestiture is not feasible within the Act's time frame. I'm sorry for these fact questions.
Sure.
But I just want to understand what's before us.
So the Act's time frame that we read, I think the divestiture had to happen within 180 days, which is 6 months, which does seem like a pretty accelerated timeline. If we consult the Act itself, I think it was 180 days. It might have been 90 days. It was either 3 months or 6 months. But it's pretty accelerated, pretty quick time frame.
Would it be feasible in any time frame? I take the government doesn't dispute that it's infeasible in the 270 days provided by law. But would it be feasible?
Your Honor, I think at least as we understand how they've interpreted the qualified divestiture provision, it would be exceedingly difficult under any time frame for two principal reasons. The first is that there's a global team of engineers that are some in China, some in Europe, some in the United States that maintain and update the original source code.
Is it accelerated? What is the usual time frame for divestment? For companies of this size, my guess is that you're going to need like a minimum of 2 years, we might guess, because there's a lot of fucking process and procedure in different companies and like over different countries. I mean, maybe you could accelerate it more than that, maybe 1 year, but...
And as we understand their interpretation, a qualified divestiture would prohibit any kind of coordination with that global team of engineers. The other reason...
Ooh, that part, what he just said, unless I'm misunderstanding something, and I must be misunderstanding something, because I'm sure he's aware of this, I don't think that what he just said is true, because I thought that the Act explicitly exempted people who are helping companies qualify for divestiture. Jesus. So this is for exemptions for certain necessary services. Subsections A and B do not apply to services provided with respect to a foreign adversary-controlled application that are necessary for an entity to attain compliance with such subsections. I thought those people were exempted, but maybe I'm misunderstanding that. Sorry.
Some in the United States that maintain and update the original source code. And as we understand their interpretation, a qualified divestiture would prohibit any kind of coordination with that global team of engineers. The other reason is because, as we understand how they're interpreting it, a qualified divestiture would divorce the U.S. platform from the global content. So, for example, there are videos created in the United States, there are videos created in Ireland. In order to get global content, we need access to the Irish videos. They need access to the U.S. videos.
I got
We
that.
understand that couldn't happen.
Okay, so you think it's probably not feasible in any timeline?
Well, Your Honor, I think it'd be extraordinarily difficult.
Okay, last fact question, then I'll yield the floor here. The government admits that it has no evidence that TikTok has engaged in covert content manipulation in this country, but says that ByteDance has responded to PRC demands to censor content outside of China in other countries. Again, you deny that in your reply brief, Somebody has to be right about that.
Well, Your Honor, the problem there is everything that follows what you just read is redacted, and so I don't know what it says. What the record shows is two things. The record shows, first, what you just said. They haven't done anything here in the United States with respect to TikTok Incorporated. And second, the record also shows through our transparency reports that we haven't removed or restricted content on the TikTok platform in other parts of the world. And TikTok doesn't operate in China, it operates in other parts of the world. We haven't removed or restricted content at the request of China. That's what we put out in our regular transparency report.
Remember, one of the reasons why the factual record is so important, the factual record doesn't just mean what's true. That would be like a fact. It's the record of those things as relevant to the court case. So if somebody were to submit a case to a court saying that I am a danger to society because I'm like 9 feet tall and I shoot javelins out my cock, and then I were to argue in front of a judge, or I were to argue in a lower court that like my javelins actually aren't harmful, that I don't shoot them, or whatever. Blah, blah. By the time this makes it to the Supreme Court, the factual record that they have before them to consult is the factual record agreed upon by the lower courts. So even if they know something might not be true, or it looks ridiculous, or they want to say like, well, doesn't China do this, or doesn't that? It doesn't matter what you think personally. What matters is what was the factual record before the court that was decided by the lower courts, then the appellate court, and then up to you before it got to you. There might be some exception if it's like a super ridiculous thing, but in general, I don't think that would survive that far, right? But yeah, so you can't consider facts that aren't outside of what's already been considered, or if you do, that's a big no-no, I believe. But
Restricted, though, doesn't necessarily cover covert content manipulation, though, right?
Well, Your Honor, I'm limiting my response to what's in the record.
Okay.
It's very
which you should be doing, right? Yeah.
difficult for me to respond to things that where I don't know what the accusation
I have other
is.
questions.
Because to respond to things outside of the record, well, you don't fucking know. Anybody could say fucking anything. Who the fuck knows? If nobody wants to submit it to a court and actually argue it, I'm not going to respond to statements made by the press or people in the media, or made to the press or made to the media, like put them in a court record and then we can argue about it there. Yeah.
Questions about the secret evidence in this case, but we'll get to that later. Thank you.
Mr. Francisco, can I ask you a question about the relevant speech here? So it's
Okay, wait, let's just mark where we think these people are at. Okay, so fuck, I should have been writing this down from the beginning. Let's see. So far, Thomas has talked about it. Roberts has talked about it. We just heard Kavanaugh talk about it. So Sotomayor spoke about it. Thomas, Roberts, Alito was at the, and then we just listened to Kavanaugh. Fuck, I should have been writing down just generally why I felt like they were against it. I should be writing down why. These are my feelings. Kavanaugh so far seemed like neutral against it, I guess. But I don't know. We'll see. We just heard Gorsuch. Oh, wait, that was Gorsuch speaking? I'm sorry. I don't know why I did this in the dumbest thing. Okay, sorry.
strikes me that this is a little different than your Bezos example, because there it's clearly content discrimination, because we're talking about the ability to post particular articles versus other articles. Am I right that the algorithm is the speech here?
Yes, Your Honor. I would say it's, the algorithm is a lot of things. The algorithm has built within it, it's basically how we predict what our customers want to see.
The editorial discretion.
Yeah, the editorial discretion. It also has built within it the moderation elements. All of this kind of comes together when the source code is translated into executable code in the United States. In the United States, that executable code is then subject to vetting, review, moderation through content moderation algorithms, and so it ultimately lands on the TikTok platform.
But what we're talking about as a net choice is the editorial discretion that underlies the algorithm. And I just want to be clear, a lot of your examples talk about, including the Bezos one, the right of an American citizen to repeat what a foreign entity says, or say, I'm hitching my wagon to China, I want to say everything China does. Here, the concern is about the covert content manipulation piece of the algorithm.
I feel like there's so many fucking insane things were said about Justice Barrett. Maybe they were true. I'm not sure. Everything I've read by her is so good. Fuck me. But this is a really interesting distinction that she's making, right? So what is the freedom of speech thing being implicated here? Because in your analogy, so she's teasing apart that analogy with Bezos and the Washington Post, right? And the argument that the plaintiffs are making here, the attorney Francisco, he's saying that if you were to go after Bezos because of stuff that the Washington Post is publishing, right, you're implicating the free speech rights of even the Washington Post is going to be burdened here, basically, right? And then so is Bezos, obviously. And what Amy is saying is, well, hold on. An American writing a post is probably a different kind of free speech than how you would tailor an algorithm. And what's being alleged here isn't even the tailoring of the algorithm. It's the tailoring of the algorithm for the purpose of some kind of subversive, covert foreign manipulation. So is that protected speech? She's drawing a distinction between those two things, which is a good distinction to draw. However, I still think the response from Francisco would be, if somebody is not disclosing it, that could be illegal under things like FARA, but as an American citizen, you still have the right to do that. You have the right as an American citizen to take foreign direction for propaganda purposes. You can't censor somebody's freedom of speech because you don't like that they're doing foreign propaganda as long as it's being disclosed, which is why Francisco's argument earlier was there could be other ways to deal with this. The Congress could force you to do some kind of disclosure, a different kind of disclosure, even a heightened disclosure if they want, but you can't come after the company and take away their freedom of speech for that. That was his earlier answer. I don't know how he'll say here, but.
That is something that ByteDance wants to speak, right?
Well, Your Honor, I think that ultimately it's TikTok's choice whether to put it on the platform.
And you don't want that. Is your client disclaiming
we absolutely resist any kind of content manipulation by China at all. But what I do want to focus in on is what their asserted interests here. They do talk about covertness, but it can't possibly be that all they're concerned about is mere covertness. If all you were concerned about was
covertness, then the law would just be to disclose. He's going to repeat the argument from earlier, right?
The covertness, untethered from the underlying content, that's something that could be easily addressed through a risk disclosure.
But that goes to scrutiny, the level
Yes, Your Honor.
of the application. I'm trying to, let's say that.
Oh, but so that's a good point too. That goes to scrutiny, meaning if they're trying to make a law passing, no, that's not a good argument. Because if they're making a law about whether or not it should be disclosed or not, right? A law about disclosure might be an intermediate scrutiny. There might even be just a rational basis. Because does disclosing something even implicate a fundamental right? But what Francisco is saying is Congress is clearly not targeting us because of the disclosure or because of foreign influence, because then they would just make us disclose it and now we're done. They don't like the speech itself. They're targeting the speech itself. The reason why they don't like the algorithm is because they think that China's manipulating it in a way that is doing foreign propaganda. That's what they're trying to get rid of, and that implicates First Amendment right, which demands a strict scrutiny review.
I agree with you, the First Amendment is implicated, and I'm trying to figure out what level of scrutiny applies, and I'm trying to figure out what content, if any, discrimination is going on here. There's disproportionate burden. Let's say that I agree with you about that. No one is preventing you. You're seeking access to a particular source code, engineering, the recommendation feature. It's the technology that you want. You're not trying to repeat, as in the Bezos example, if we take the speech that the government's concerned about to be the covert content manipulation rationale, you're not seeking to utter that speech.
That's correct, Your Honor. What we are seeking to do is use an algorithm that displays the combination of content that we prefer our users to see on the platform.
And the government doesn't care about that. The government is fine with you doing that.
Well, she says that, but his argument is contrary to that. The government's not fine, because if the government was fine with that, then they would be forcing a different type of law about disclosures rather than trying to ban it entirely, right?
You can invent it yourself. It doesn't even care what content that displays, cat videos or whatever.
Yeah, but I think that the way that the analysis has to unfold is first you ask, is this law burdening our speech? I think we agree that the law is burdening our speech.
Obviously.
Then you have to look at whether the law itself
Is narrowly tailored.
somehow content-based, not just what their motivation.
Oh, never. Okay. It's content-based. Well, this goes to the tailoring of it, right? Like, what are they trying to ban exactly? Because it has to be a very precise, like surgically targeted law. It can't be a blanket huge law.
Are, but whether the law is content-based, and here the trigger for this law, the one thing that gets it going is if you operate a social media platform that has user-generated content, unless that content takes the form of a product, travel, or business review.
So this is a strange carve out from that law, because if there were security concerns here, why would you carve out things that do like travel reviews, right? So these are companies that can't be attacked. There is no cause of action on the behalf of the federal government because of this law, and the carve out is for the term covered company does not include an entity that operates a website, desktop application, mobile application, or augmented or immersive technology application whose primary purpose is to allow users to post product reviews, business reviews, or travel information and reviews. But why? I don't know why this carve-out exists. I'm not actually sure. I don't know what the debate was in Congress for it. But this is also something that's brought up in their request to, in the request for the writ for certiorari for the Supreme Court to hear this case as well, is when they say, why do you have a carve-out for this? It doesn't make any sense.
Then within that universe of content, it says there's one speaker we're particularly concerned about, and we're going to hammer home on that one speaker. And then just to make the rubble bounce, they come in and tell us that one of the reasons they're targeting that speaker is because they're worried about the future content on that platform, that it could in the future somehow be critical of the United States or undermine democracy, to pull examples from the government's brief. So I think there's no way to get around the fact that this is a content-based speech restriction, and you do have to go directly to what their interests are. Now, their principal interest is...
I think I'm a little bit surprised by one of the answers that you gave to Justice Barrett.
Is this Kagan speaking? I don't know their fucking voices. That was I wanted to hear that line of questioning more. Fuck. Because this is probably the weakest or strongest, or this is probably one of the big points I would imagine of deliberation here is like, is this a target on TikTok's speech, like in this way, or I feel like this is an important thing to hammer home, but whatever.
Understood that TikTok's essential complaint here is that they wouldn't be able to use the algorithm that ByteDance has invented, and that they want to use the algorithm that ByteDance has invented.
100%. And if I was unclear on that, Your Honor, I apologize. That is absolutely
because I think
the core
what
of the
Justice
claim.
Barrett was saying to you is like, what's the problem here? Because ByteDance is a foreign company. Or maybe this isn't what Justice Barrett says, it's just what I say. ByteDance is a foreign company, and you started off with Justice Alito saying, well, we would be making a different argument, and of course that's true. I mean, I would think that Alliance for Open Society makes it pretty clear that you have to be making a different argument with respect to a foreign state or a foreign company. So let's say that they don't have First Amendment rights. The only First Amendment rights lie in TikTok, which does have First Amendment rights. I guess my question is, how are those First Amendment rights really being implicated here? This statute says the foreign company has to divest. Whether or not that's feasible, however long it takes, TikTok still has the ability to use whatever algorithm it wants.
Does TikTok have so let's say that they force the divestment. Can't TikTok simply continue to use ByteDance's algorithm? The answer would be no, because it's ByteDance. Now you have to cut ties with that company. You might not have access to what they would license you anymore, no? You're burdening the speech. Maybe now TikTok has to pay some huge sum of money, or maybe ByteDance just doesn't license that algorithm to them or sell that to them. So this is hugely burdensome. So you could do this. You could use the algorithm, but this is burdensome. You have to go through more steps to do it. So whatever law is making this happen has to survive a strict scrutiny, I would imagine.
Doesn't it?
No, Your Honor. And their rights are implicated at a most basic level. In 10 days, TikTok wants to speak. In 10 days, because this law was passed, TikTok cannot speak unless ByteDance executes a qualified divestiture.
Correct.
That's not just ByteDance's choice. That is a condition
I
that's
realize
imposed
that
by law.
it definitely has effects on TikTok if
Not just an effect, it's burdensome, right?
ByteDance acts in the way that you are assuming it will act. So this is not to say that the First Amendment isn't involved, because TikTok is going to suffer some pretty severe incidental effects.
Yes.
But they are incidental, aren't they? Because the statute only says to this foreign company, divest or else, and leaves TikTok with the ability to do what every other actor in the United States can do, which is go find the best available algorithm.
That's not true, though, because it's only targeting companies that might have owners that have at least a 20% stake in your company from other adversarial countries. So like, let's say that there was let's say you had like Jew Talk instead of TikTok. Jew Talk wouldn't be burdened in the same way, right? I think that burdensome stuff that only targets like a particular thing, suspect would be for strict scrutiny, right? You need a very, very, very compelling argument to do this. I don't think this would impact everybody equally. And that's obviously the case, right? This isn't happening. Like X and Meta and Google are not having this conversation right now, right? Mark Zuckerberg, new podcasters with Joe Rogan is wild. He basically says the Biden government put pressure to take down basic criticism about vaccine side effects. Love to see you watch. Yeah, we might watch it later. We'll see.
I very much disagree that the effects are incidental, because the way that this law works is it is only triggered if somebody is engaging in speech based on their content. User-generated content, except for business, product, and travel reviews.
That's true, too.
It then singles out a single speaker, and you have the concession for the government that one of the reasons they've singled out that speaker.
A lot of emphasis on the idea of just like, I think what you're basically saying is that all speaker-based restrictions generate strict scrutiny. I'm not sure that we've ever said anything like that. Let's put aside the
that speaker-based restrictions require strict scrutiny. We've never said that. Well,
anything like restrictions. I think what you're basically saying is that all speaker-based restrictions generate strict scrutiny. I'm not sure that we've ever said anything like that.
Oh, that's true. Because if the speaker has to do with like a non-suspect class, that wouldn't necessarily trigger strict scrutiny. That is true. Now, I'm sure he'll argue that maybe because it's based in another country, there's like a nationalistic or there's a racial aspect to it, I think, which is more in line with that. But well, Felix, thanks for your private supper.
Let's put aside your argument that this is facially content-based. It seems to me that your stronger argument, or at least the one that most interested me, was this argument of, look, if the government is doing something specifically for the purpose of changing the content that people see.
Destiny, but she is saying that that is incidental, not a burden imposed by the law, but a burden imposed by the economic landscape. All companies are such that they could not be owned in the way TikTok is owned now. Divestment is thus necessary in TikTok's case, but that any company could likewise contract with some other company to license an algorithm, the speech. Okay.
For the purpose of changing the content that people see. That has to be subject to strict scrutiny. But I don't see that for the purpose of changing the content that people see. That has to be subject to strict scrutiny. But I don't see that as affecting TikTok as opposed to as affecting ByteDance.
Well, no, I very much do see it as affecting TikTok, because they choose this algorithm because it reflects the mix of content. The government's fear is that China could come in and pressure TikTok through ByteDance to TikTok to alter that mix of content to make it too pro-Chinese or too anti-American. That is very much directly a content-based charge straight at TikTok. The other point I would like to...
I hear you that it might very well have that effect. I guess what I'm suggesting is that the law is only targeted at this foreign corporation which doesn't have First Amendment rights. Whatever effect it has, it has. You know, maybe ByteDance will figure out a way to like put this on open source, and then TikTok will be able to use the.
Oh, okay, I understand more. What the chatter said and what she means by incidental is this law is truly just targeting. The law is targeting ByteDance, which is the foreign owner, but damage is done to TikTok are just incidental. It just happens to be this way because of that foreign owner. But so the foreign owner is really who's being implicated here, and then any damage to TikTok is just incidental.
So, Your Honor, if I could take that on directly, because I think TikTok has First Amendment rights to the extent ByteDance is speaking in the United States.
Oh, so I understand. So the real First Amendment challenge, because you're challenging their First Amendment challenge, is that TikTok's right to speak or engage in whatever algorithmic thing they want, that's not being implicated. You're just, what's happening, the reason why the algorithm itself isn't being attacked, it's the person that you're buying it from that's being attacked. And that's not a First Amendment challenge. And that wouldn't demand a strict scrutiny analysis. That might not even be intermediate. That might just be rational basis. That makes more sense. This would be like me saying, so now the analogy would be like me saying, let's say that I stream every single day and I get my microphone and my ability to publish online from Russia. And let's say the United States government sanctions Russia for some bullshit. And I'm challenging the US government. I'm saying, well, hold on, you're going to sanction Russia? You have to provide a very, very, very compelling argument to do that because my First Amendment right is implicated because now I can't get my stuff from Russia anymore. That's not a First Amendment violation on my part. That's incidental harm to me, but it's not directly implicating me. Yeah, that's a really strong argument, I think. That actually might have changed my opinion on this, I think. But we'll see. I don't know. Maybe this guy will argue his way out of it. Why did I think this was a good argument before? Because TikTok is being uniquely harmed here. But they're not. They're being incidentally harmed because of the targeting of ByteDance. He's arguing that it's because of the content. Oh, well, okay. But the counter argument is, well, hold on. You're not just broadly targeting ByteDance. You're targeting ByteDance because of my First Amendment exercise, because you're literally carving out like other businesses, but it's because I'm engaged in freedom of speech. Your interest is in curtailing my freedom of speech. You happen to be targeting ByteDance, but I'm the actual target. Because if I didn't exist as a company, this law wouldn't exist, right? There would be no law targeting this type of behavior because ByteDance would just be doing things in other countries. I think is the counter argument. Ooh, that's actually a hard one. I don't know. Wait, never mind. I'm back. I'm back with TikTok, I think. Why are you targeting ByteDance? You're targeting ByteDance because of my activity in the US, not because of... Never mind. I'm back. I think I'm back on TikTok's side, but maybe we'll see. Okay, let's go. Let's see. I don't know.
It, I believe, has First Amendment rights.
Sorry, hold on.
Directly, because I think TikTok has First Amendment rights to the extent ByteDance is speaking in the United States. It, I believe, has First Amendment rights. If you conclude that neither has First Amendment rights, then surely the creators have First Amendment rights. But if you take a step back, what their position is that none of these entities, this is the universe of entities affected by this law, none of these entities have the authority to assert First Amendment rights, which means that the government really could come in and say, I'm going to shut down TikTok because it's too pro-Republican or too pro-Democrat or won't disseminate the speech I want, and that would get no First Amendment scrutiny by anybody. That cannot possibly be the case. The government really could come in and say, I'm going to shut down TikTok because it's too pro-Republican or too pro-Democrat or won't disseminate the speech I want, and that would get no First Amendment scrutiny by anybody. That cannot possibly be the case. Yet,
why would they? What part of this law gives them the ability to say that? Because you have to be, it would have to be foreign owned, right? There has to be that 20% foreign ownership in order to be a covered company, right? It has to do all 4 of these things. Permits a user to do this bullshit, basically be a social media company, has more than 1 million monthly active users, enables 1 or more users to generate or distribute content that can be viewed by other users. So these are like social media, and then enables 1 or more users to be generated. And then it has to be controlled by a foreign adversary. It couldn't just be that it's Republican and we don't like them, right? I think. I'm going to go back to the start of this answer.
None of these entities have the authority to assert First Amendment rights, which means that the government really could come in and say, I'm going to shut down TikTok because it's too pro-Republican or too pro-Democrat or won't disseminate the speech I want, and that would get no First Amendment scrutiny by anybody.
Oh, he's not even saying per this law. He's just saying in general. If we were to say that these companies have no First Amendment rights, then they could literally be shut down for any fucking reason. Like the government could say, okay, he's not even referencing, he's not saying with respect to this law, he's just saying in general, if we're going to say that there's no First Amendment rights here, then this opens the door for all sorts of speech restrictions, right? Okay.
That cannot possibly be the case, yet that is the effect of their position. The last point I'd like to emphasize, though, is this law, like the Playboy case, like the Hobby Lobby case, has built within it a less restrictive alternative, which is the general provision, by definition designed to protect against the very harm the government is identifying. Suppose New York State passes an asbestos abatement law. They say these types of buildings have to abate asbestos. In addition, New York Times, you have to abate asbestos in your building, and they say there are 2 reasons for this. 1, we want to abate asbestos. 2, we hate the New York Times editorial page. Surely, at the very least, what you're going to say is you can't target the New York Times directly. What you can do is throw them into the general process.
Thank you,
we
Counsel.
think that's the minimum that should be done here.
Thank you, Counsel. We've been talking about connection between the regulation of TikTok and the burden on expressive conduct. And your basic position is that interfering with the ownership of TikTok constitutes a direct regulation of the expressive conduct of other people. What is your best example in our precedent of a situation where a regulation of corporate structure or something else has been treated as a direct regulation of expressive conduct?
The regulation of a corporate structure as
So one of the laws that the government wants to make here is this is just like a structuring of your company provision, basically, that's being enforced with private cause of action from the government, right? We're going to sue you if the structure is incorrect. So Roberts is asking, can you think of another example? Because right, common law tradition, whatever else, like it's important to have cases that have been ruled on that are similar to your case, because then you can point to, well, in our legal tradition, look, this has failed here, or it succeeded here or here. So Roberts is asking, is there any other time where the regulation of corporate structure has required strict scrutiny because it implicates a First Amendment right, just because of how corporations are structured or some corporate structure like that? That's a question that Roberts is asking here.
Of expressive conduct.
The regulation of a corporate structure as Your Honor, I don't have a case at my fingertips. I can consult.
Well, I don't have one at my fingertips or any other
rebuttal, but I think it's quite clear, though, that if you're saying to a company, you have to stop talking unless somebody else does something, and that's imposed by the force of law, it directly affects that company's speech.
Well, it's again, I don't.
You have to stop talking unless somebody does something else. Oof, this is like really hairy territory. Because the civil penalties would be imposed on the TikTok company. That's true. They're not just imposed on ByteDance, the owner. They'd be imposed on TikTok as well. And you're saying that TikTok's speech is limited based upon the actions that ByteDance takes. So that burden exists. I don't know. Oof, all right.
I don't know if it's directly affecting the company's speech or the speech of third parties, and I'm not.
Yeah, and then the question is it direct implication or is it incidental or whatever, right? Maybe. Yeah, I don't know.
Not sure what where your emphasis is. But again, I'm not sure there's another case where we've said that regulating a company others' expression should be treated as direct imposition on their speech in terms of the standard of review, for example, when it's based on derivative regulation of corporate structure of somebody else.
Well, they would only be imposed on TikTok given the condition they don't divest from the foreign company. So you can't divest from your owners, my friend. The owners divest you. That's like saying I'm owned by Google, but actually I declare I'm divesting from Google. You're divesting from Google? How much? No, I'm divesting their ownership from me. No, excuse me. Google has to divest from you. They own you. You can't just say I'm no longer owned by them, right? The divestment works one way.
Your Honor, I think that I would concede that this is a pretty unprecedented case.
Yeah.
I'm not aware of any time in American history where the Congress has tried to shut down a major speech platform. But I think that...
Why can't you just be bought out? People are offering to buy out the company? What do you mean? Because you can't just buy shit from... You have to force another company to sell. And right now, nobody's being forced. It's just a choice, right? You can't force... Yeah. So it could be the case that ByteDance says, oh, well, this is untenable. We're just going to shut TikTok down. And then they leave. And TikTok has no recourse there. They can't say, well, we don't want to shut down. We want to be sold. They just say, well, we're shutting them down and then leave.
If a law imposes a direct regulation on a third party, that in turn results in shutting down somebody else's speech, and they do it for content-based, viewpoint-based reasons, and in particular on this record, because the speaker that is ultimately being shut down, they don't like the speech of that particular platform, that's a real problem.
So it may be a real problem remaining.
So just to understand the whole argument chain here, okay. Jesus. So the argument is from the... Wait, what do you call them? Not the plaintiffs. From the petitioners? Or no, they would be the plaintiffs here. Okay, so from the plaintiffs, the argument is the government is trying to, the government has created a law that is forcing a U.S. entity whom enjoys First Amendment protections to potentially cease operations where freedom of speech is implicated based on the actions of a third party who's implicated by said law only due to the government disliking the content or speech of the U.S. entity involved. I think this is the chain. I'm trying to think if I can simplify this more. I think this is basically the argument that that TikTok and ByteDance are going with, that the government is creating a law that's forcing a U.S. entity, in this case TikTok, who should enjoy First Amendment protections, which invokes ideally strict scrutiny review, to potentially cease operations. So they're going to stop doing a thing, which is very clearly like a freedom of speech thing, right? Based on the actions of a third party, which is ByteDance, who's being forced to comply with this law from Congress, who's implicated by said law only due to the government disliking the content, speech of the U.S. entity involved. Okay, this is the full argument. And I think every single one of these things has to stand on their own, or they all have to stand, and if any falls, then it's okay. So for instance, what are the 1, 2, 3s of this? Okay. The government has created a law that is forcing a U.S. entity hold on, let me just, so we have, okay. The things that TikTok and ByteDance have to argue successfully here is that TikTok's speech is implicated, and their speech being access to control of the algorithm. The law passed by the government is implicating content/freedom of speech. So this law is not just a national protection law or whatever. It's a law that is directly implicating the freedom of speech. And that, and I think they might have to argue also that, that TikTok's survival depends on a foreign party's response to said law. ByteDance/China's response to the law/lawsuit, I think, right? I think these are the three things that have to, TikTok has to get all three of these things down in order to win their case here, basically, right? I think. Why not Congress instead of the government? When you're talking about lawsuits, you're always talking about the government because Congress has nothing to do with lawsuits. Fuck, there's a fancy Latin bullshit expression for this, but Congress can't do lawsuits. It's the Congress. All they can do is pass laws. The government is always the executive branch because they're the ones that enforce laws and bring lawsuits. So when we talk about the Department of Justice, or we talk about the Department of Justice or the government suing somebody, it's always the executive branch. It's always the DOJ.